Hi all. I've created a presentation on creation of land bank committee, which has been prescribed by Ministry of Environment, Forest and Climate Change in India. They have been asking us to do this, and I made a presentation to put up this matter to my senior officer. I thought, why not? It may be kind of useful to other people, other states, other forest officers, and even students, because it gives a background of compensatory afforestation, what is forest, definition of forest by Supreme Court. So that's why I thought I can share with you all. The agenda of this PPT is why there should be a land bank, what is the context, and what is the MOEFCC guideline says, and number one. Number two, definition of forest by the Supreme Court. As you can see here, what I've written. The legal background based on two cases. One is Godavaraman case, which is very popular, and another one is the Lafarge case. Lastly, we'll discuss about the concept of land bank and the ecological approach given to it. It is a well thought approach. And finally, we'll discuss, or we may see, about the critical analysis of why it's not, what are the challenges in implementation of this land bank committee. The MOEFCC guideline says that we have to, every state forest department has to identify land bank for compensatory afforestation, which is a necessity for speedy disposal of Forest Conservation Act proposals, which means that whenever there is a project comes up which has to be processed under the Forest Conservation Act for diversion of forest land for some non-forestry purposes, maybe it's for development, mines, road, rail, or any industries. So we have to compensate the lost forest. We have to create a compensatory afforestation in a new land that is a non-forest land, or if it is a central government project in the same our own forest land, that is a degraded forest land, we have to do. So for the state government, they don't have the benefit of giving the fund for compensatory afforestation, or we can say they should find like a private agency, they have to find land. Yeah, non-forest revenue land they have to give in compensation. So herein the MOEFCC ministry's guideline says you can ready-made keep a land bank. That can be any forest, any wasteland. It can be kept ready for, as we have a land bank for industries, we can have a land bank for compensatory afforestation, so that all the developmental projects that the state government wishes to have, they can have it early. They don't have to search for the compensatory afforestation land. But what they've said is, within the land bank, apart from the land, whatever available, you should also include all land where FCA is applicable. I mean, where the Forest Conservation Act is applicable. So now, what are all the lands where Forest Conservation Act is applicable? For that, there is a Supreme Court order which defines what is forest. It's very popular Supreme Court order, the Godavaraman case, number one. Number two, again, it is emphasized in another Supreme Court order, that is in Lafarge case. So we are going to discuss about it. The states within that Lafarge case, the Supreme Court ordered that every state should prepare a geo-referenced district forest map containing the details of the location and boundary of each plot of land that may be defined as forest as per the Forest Conservation Act. And such land, once we have earmarked, one we have defined, one we have made as a layer in GIS, once it is geo-referenced, we can keep it in the land bank. If it is empty, if it is degraded, if it is already having forest, fine. If it is degraded, we can keep it in the land bank, so that whenever the state government wants to propose any developmental projects, they can, instead of searching for new land for compensatory afforestation, they can use this land. So now we are going to the background, the context of why Supreme Court defined forest within the Forest Conservation Act. How is it different from the forest which we see under the Indian Forest Act? For that, we have to go deep into this Godavaraman case, which is a landmark case in India's legal history on forest conservation. Many people know that. The background is forest areas of Janmam land in the Western Ghats of Nilambur Kingdom was taken by the states of Kerala and Tamil Nadu. Uh, in Kerala, they had the Kudalur Janmam Estates Act in 1969, and Tamil Nadu had Tamil Nadu Estates Act 1948, whereby they acquired land from Jamindaris, kingdom, princely estates, and they've redistributed. You know about the Tenancy Act and land redistribution. So in 1995, TN Godavaraman Thirumal, he is was a member of the Nilambur Kingdom family himself, and he's also a conservationist, environmentalist. So he said he was distressed on seeing the destruction of pristine wooded areas in Gudalur in the Nilgiris area, where he was himself, where his family owned large stretch of land, and now it is given to the government of Tamil Nadu. He approached Tamil Nadu government and he asked if this forest can be protected, because he could see on both the roadsides woods are cut, and even he said in one of his articles that timber mafia involved, and he was even approached, so on. So, but Tamil Nadu government said there is no provision to protect the forest because it is not a notified forest under Indian Forest Act, and there is legally they don't have provision to protect such forest, which is now vested with the government. It is not under the Indian Forest Act. So now TN Godavaraman went to Supreme Court and he asked a simple question: why should why should the forest conserved based on the ownership? Because whether a private person owns forest or the government owns forest, whether it is notified or not notified, the ecological benefits of both the kind of forest is the same in terms of conservation of wildlife, in terms of other ecological benefits for like formation of rivers, etc. So he asked a simple question: why should there be a conservation only based on ownership, only based on notification, only based on whether it is government forest or not? So against this, Supreme Court gave an order, and they defined, or they kind of redefined, what is forest. They said forest under Forest Conservation Act 1980 is defined based on achieving ecological balance than giving a protection based on ownership. It gave a mind-bending definition. It said forest includes, as per the Forest Conservation Act, it includes all government-owned forest, whichever the agency under government owns it. For example, the forest department or irrigation department or any other department, any other agency. If such land is defined as forest, then it will be under the Forest Conservation Act. If all such land under any government department, which even not yet notified and given to the forest department, can be called forest under the Forest Conservation. Number one. Number two, the Supreme Court order said if the nature of a government owned land is forest in dictionary sense, I mean, even if it is notified, classified, recognized, or not notified, or not classified, or not recognized as forest, still it will be said as forest for the purpose of Forest Conservation Act. Another thing what the definition in the Supreme Court order said is government owned areas which were earlier forest, a natural forest, but now stand degraded. Now we can't see forest in it. There is no dictionary sense also. There is no forest. It is denuded, it's cleared. Even such area can be defined as the forest for the purpose of the Forest Conservation Act. It doesn't include the private plantation, but it includes private forest. If it is a natural grown forest, it is not. It doesn't include orchards or private plantations, as it is said under forest cover. It is not forest cover. It is natural forest. Now, after this mind-bending definition, there are several implications. The implication of the new definition of forest is like this: what Supreme Court has told, they have not told to give this forest land to Forest Department and put it under Indian Forest Act. No, it requires lots of process of forest settlement, everything. Supreme Court only ordered to stop diversion of such land or take central government permission for diversion as per the procedures established under the Forest Conservation Act 1980. Further, they also told make an expert committee to identify such forest areas wherever they are and one of the now proposal by MOEFCs put it under the land bank. So now this is the Godavaraman case. Now coming to the Lafarge case, what happened in Lafarge Supreme Court order is this. Lafarge is a cement company. They bought some land in the Indian side in the Meghalaya, East Khasi Hills, to supply the dolomite raw material required for manufacturing cement, which the company was established in the Bangladesh side. So they already even established everything. They've established a large transport mechanism, a 17-kilometer long conveyor belt to transport the limestone from Meghalaya to the plant in Bangladesh. So this land doesn't actually belong to the forest land from where the mining forest, the ownership was not with the forest. So here again, I gave a small brief. You can take a glance. The Lafarge judgment is 130-page long order, so I very briefly quoted it here. The main idea here is like they got clearance way back in 2000, and the mining extraction was completed for about 20 hectares. As I've noted here, the land doesn't belong to Forest Department. It belonged to the East, Khasi Hills Autonomic District Council, and they got permission. It went through the environmental clearance and FCA clearance also, but uh, later they found the FCA clearance, Forest Conservation Act clearance, was were wrongly obtained. Project was halted in 2007. When the project was halted in 2007, Lafarge said no. Even Defort signed a report which said the forest, the land, the actual land is a wasteland. Yes, the ownership of the land, the category of the land is a wasteland, but it had a natural forest over it. But MOFC sent an inspection committee and they confirmed that it had a thick natural forest. So there was an ambiguity on Forest Conservation Act applicability of the land on the matter whether the natural forest owned by Hill Council will be coming under the forest as defined under the Forest Conservation Act. Here, the Supreme Court again hammered and told, we already told you in the TN Godavaraman case, such land is defined, you have to go with the dictionary sense of forest, and even if it is not classified or notified, if the nature of the land is forest, or earlier it used to be natural forest, now whoever owns it, even if there is no forest, it should be taken as forest, and we have to conserve it, or we have to do afforestation in such land as per the Forest Conservation Act. The Supreme Court told all states, at least from now, you should have a district-wise map on all FCA applicable forest land, so that the user agency and all stakeholders know it beforehand, and there is no such confusion arises. Supreme Court told MOFC, in general, MOFC should govern the Section 2 of Forest Conservation Act, which actually decides whether the forest land should be diverted or not. It should be on the basis of National Forest Policy, 1988. The ultimate objective of this is not related with the Indian Forest Act. The ultimate objective of this FCA is to meet the end of India Environmental Protection Act, 1986. So that is how the Supreme Court defined, and that is how the birth of the concept of land bank came. And MOFC has continued with that nicely and said, here I'm quoting again what the Supreme Court judgment said, so that fate and complete situation does not occur. Because what happened in the Lafarge case is already they have diverted, now they are forced to regularize that. There is no kind of post facto. We can't undo whatever has happened. So the Supreme Court told to avoid the situation. So every state have to complete the exercise in compliance of the earlier court order 1996 in the Godavaraman case, wherein, among other things, the court told every state government should have expert committee to identify the areas which are forest, as per the definition given there before, irrespective of whether they are notified, recognized, or classified under any law, and irrespective of the land of such forest and the areas which were earlier forest but stand degraded, denuded, and cleared. And this should culminate in preparation of a geo-reference district forest map containing the details of the location and boundary of each plot of the land That may be defined as forest for the purpose of forest conservation in 1980. Again, in the second case of Lafarge, judgment Supreme Court told to the forest officers and conservationists that your conservation approach mm, should not be narrowly based on the ownership of forest. It should have ecological approach, and they also specifically told, please please survey and take a map of such area where which can be called as forest for the conservation purpose. So now the question arises: once the forest is identified, what to do with that land? If it is having forest yet, fine. If it is still having forest, that is good. If it is not having forest, if it is empty, if it is degraded, what is it? What is the point of just not allowing it to divert? So the MOEFCC came up with a nice idea of land bank and said, you put this such land, you survey, and whenever you find a degraded forest land, put it in the land bank so that under the Compensatory Afforestation component of CAMPA, that is Compensatory Afforestation Fund Management Planning Authority. Now every state is given 90% of their fund from the central government. They have transferred their funds. For example, West Bengal, we have 267 crores for that. And they said whenever state government makes any project, say this land, if we are able to identify, we can put it in land bank and we can go for ecological conservation of such land. This is one aspect, and another aspect is it is not only for compensatory afforestation. We have to improve the wildlife corridor because, for example, if one area is connected with another area where for thousands of years, say, elephant used to move. Now new habitation came in, and the elephants still move, and the human elephant conflict is partially man-made due to lack of landscape approach, and yeah, you know these things like expansion of habitation and many other reasons. So they told why as much as possible, we can recover those empty forest classified land which is held with DM or any other agency, not necessarily with forest department. So we can improve eco-sensitive zones, and we can also improve the habitat of endangered species, and without the ownership approach, wherever natural vegetation is there, which makes the catchment of rivers, irrigation system, we can enrich them. So these are all the concept Ministry of Environment, Forest, Climate Change they told about the land bank. Now I try to make this a simple diagram. These are all kind of notified forest under the forest department. For example, this is in the left side, you can see the one DFO having a chunk of land, another DFO, yet another chunk. There may be other kind of forest classified as forest or not classified, but originally a natural forest whose ownership may be with different agency, maybe district magistrate or irrigation department or any other department, or maybe it a private forest even. So now maybe it has had now habitation, which but still elephants may be moving as they used to move for thousands of years. They may be contributing to the watershed. Why should we think about only the DFO's forest, notified forest, which our approach should be comprehensive. So this is the ecological approach of land bank. So, but while actually, some of the land are converted, those forest land not with the forest department, they are converted for industries, but again for converting for industries, which we need compensatory afforestation to be done. So if new land is given in some remote area where there is no soil depth, and where there is only boulders, where we cannot raise plantations or forest, the compensation is not possible. At no stretch of imagination we can compensate the loss even by raising plantation, because we lost the biodiversity. So even that plantation is not possible when we give a remote place where a new forest land is given. Instead, we can consider this forest land where originally it used to be forest, but now it is degraded. This is the whole idea of ecological approach of the land bank. Now, coming into this is the last slide. What are the constraints in doing this? Why states are not able to do? Only few states like Orissa, Karnataka, which had mining issues, court cases like Shah Committee recommendations, they could do this land bank well. Why not states moving up to? Why not states more interest? They're not showing more interest for land bank committee or land bank. this is the reason I found out, having working as chief conservator of forest, handling this Forest Conservation Act, is number one, what about the forest land that was already diverted by the government? They would have TM would have diverted it already for industrialization, or they would have made patta, title would have been given. So now, if you say go and reconcile, find out the forest classified land which is with TM, they are not going to show the data. They are not going to do it, because the question arises like, uh, even if they're willing to give the land which is empty, how about the land that is already diverted? The MOFC is silent about it. No, nowhere they have mentioned about it. So there should be a practical idea. Okay, whatever is diverted is diverted. Whatever balanced land, please consider it. If it doesn't have, if it is empty, you consider it to put it in land. But that can be a practical approach, but that has not been taken till now. Number one. Number two, another disincentive of what I found is, if the state government makes a project, say a mining project, it has to give a compensatory afforestation land. If they are giving a non-forest revenue land, they can, it's enough if they give only the equal amount of land. For example, 10 hectare is diverted, it's enough they give 10 hectare of a compensatory afforestation land. But what this MOFC guideline says if they are giving from this forest classified FCA applicable land, they have to give 2 times of land. That's what the MOFC guideline says. But why would they give? That's a question I want to raise with the senior officers, respected officers in the MOEFCC. So it is kind of disincentivizing states like West Bengal, which is a land-starved state with the highest population density in the country. So one welcome thing is, MOFC has told the definition of forest can be is now left to the state government. They can define forest. But coming to the land bank, coming to seriousness of compensatory afforestation against the lost forest, we have to address these two questions. And I would, when I say this, I also appreciate the efforts taken by Ministry of Environment and Forest. We had the old last DG Forest all the way came to state of West Bengal, and he gave a nice presentation on why should we have a land bank committee. Thanks for listening. Have a nice day.